Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin, LLP. I'm located in Toronto. It's great to be back with you guys. I've done many of these Q&A sessions, and I'm excited for this one. As I usually say, we have offices across Ontario, British Columbia, and Alberta, and we offer many of these Q&A sessions every single week in order to ensure that your employment questions are answered. It is a free, anonymous use of time here, so please utilize the time wisely. Send in your questions, and I'll be sure to get to as many of them as possible. Before we delve into questions, what I usually like to do is start off with a hot topic in employment law. And so the topic for today is layoffs. We've talked about this many times. Layoffs continue to occur, especially in the tech industry. We're seeing many waves of layoffs. And just recently, we caught wind of the fact that Dell is laying off employees, approximately 12,500 employees globally. We're not exactly sure how many will be from the Canadian offices yet. I'm sure we'll find that out soon. And we understand that many of the layoffs are going to occur for more senior employees or management or executive level employees. And so the key question here is, what are their severance entitlements? If the employee who's terminated is an executive, do they perhaps have greater severance entitlements than a mid-level or junior level employee? And the answer to that is usually yes, they do. We are able to usually secure greater severance packages for executives or C-suite level employees. And the reason for that is because the law recognizes that it is typically more difficult for those types of employees to re-employ. Okay, and so they need a greater severance package in order to bridge the gap of unemployment. On a similar note, there's a question of, does job availability impact one's severance entitlements? And the answer to that is yes, it does. The whole notion of severance, and this is very important for everyone to understand, is in order to get an employee who's terminated from one job to the next. Many employees who I speak with think that, they're loyal employees, they work for a company for a very long time, and they've invested so much in the company and in terms of their time. And so they must be owed a severance package if they're terminated. And the answer is they usually are owed a severance package, but it's not because they were loyal employees. Really, severance more has to do with the employer having the obligation to bridge the gap of unemployment for the employee. And so therefore, if an employee is more senior and that length of unemployment is likely to be longer for a more senior employee, they'll be owed more severance. Similarly, if the employee who is terminated works in an industry where it is more difficult to find a job, such as right now, the tech industry, because there are so many layoffs, it might be harder to find a new job for someone who's terminated in the tech industry. And so that type of employee would be able to secure, in all likelihood, a greater severance package than an employee in another industry that is not impacted by layoffs. So this is all very important for everyone to understand. It's an important topic. It's impacting many Canadians. So I hope that was helpful. We'll now delve into questions. Okay, so we have a question from Steph on YouTube. Steph says, hello, if my employer is closing down our existing location and wants me to move to a new branch, is that something I have to accept? Great question. The answer is it depends. And like many legal questions, the answer is it depends. If the employer is closing down the location you work for and they want to move you to a new branch, you're going to have the same job, you're going to earn the same amount of money. Really, your job will be identical, except for the fact that you'll be working at a new branch, then yes, you might have an obligation to accept that job. And if you don't, it would be considered a resignation. However, if that new branch is very far away from your home, and you had a commuting time of, let's say, half an hour to and from the office, and now it's going to be an hour or more, then that would be a substantial change to the terms of your employment. One of the terms of your employment is where you work. And so if you are now being offered a position that is identical, except for in a location that's much farther from your home, thereby increasing your commuting time, you don't have to accept that. That would be what we call a constructive dismissal. And you would be able to obtain your full severance entitlements if your employer constructively dismisses you, and in this case, forces you to move to a new branch. Okay. So Steph, I hope that answers your question. If you have any follow-up, of course, please feel free to post it in the chat. Okay, so we have a question from Ash MK on YouTube. Do not-for-profit or charitable organization employees have the same entitlements? Yes, you should. If you're an employee for a charitable organization as opposed to a for-profit organization, you're still considered an employee. You're still governed by the legislation in Ontario that governs employment relationships, which is called the Employment Standards Act. And so you will have the same entitlements. If you have a more specific question about a specific entitlement, I'm happy to answer that. We have many good questions today. I'm going to move on. We have a question from Saul. I am a truck driver, and my company wants to install a dash camera in my truck, which will record the road and inside my cab recording me with audio. Is this something legal that the company is doing? So it will depend on whether you work for an Ontario regulated employer or a federally regulated employer. There are different jurisdictions. And I raise this because sometimes drivers work for companies that are regulated federally, and sometimes they're regulated provincially. It really depends on whether you cross borders or not. And there are different laws in each realm with respect to privacy. In either case, though, across the board, you should be aware of the fact that you're being recorded. It's not an uncommon thing. It's often usually for your own safety, and also to record if there's some sort of accidents that might exist on the road between the truck that you're driving and another vehicle. So there are important reasons for why an employer would want to install this kind of camera. But again, you should be aware of it. And if you have any issues with it, you should raise that with your employer. Okay, good question. Moving on. A question on YouTube from Zamidar. My employer promised me accommodations in the workplace when hiring me, but now that I've started, they're saying they can no longer provide this. What can I do in this situation? Very good question. I deal with this very often in my practice. You're dealing potentially with a human rights issue here. If you require certain accommodations, for example, it could be that you need longer break time at work as a result of anxiety. I had a client who specifically required that kind of accommodation. It was medically documented that they required longer break periods. Something reasonable, employers should be able to implement that. And the employer did convey to the employee that they would be able to implement that, and then they retracted that. So a similar situation to Zamidar's situation. And that is a human rights issue. That is potentially discrimination, or what we call a failure to accommodate. And if that happens, then you can bring a dispute in front of the Human Rights Tribunal and potentially obtain damages for your employer's failure to accommodate. In order for this to be successful, though, you really have to ensure that everything's well documented. And by that, I mean the medical documentation exists where your medical professional has stated what kind of accommodations you need. You ensure that those medical notes have been received by your employer. Your employer has a full understanding of the kind of accommodations that you require. And any correspondence you have with the employer about this should be in writing in order to obtain all the potential evidence that would be necessary to prove your case in front of the Human Rights Tribunal. So this is an issue. It's a very good question. And just ensure that the medical documentation exists, ensure that all your correspondence is happening in writing. And if your employer does fail to accommodate you, you can bring a dispute in front of the tribunal in Ontario. Okay, let's move on. So we have a follow-up from Ash. Ash asked about the severance entitlements for an employee working for a charitable organization. And Ash now says that the employer, the organization, has said that their entitlements are not the same, has not indicated what the difference is, but just that the employees of a charitable organization don't get the same entitlements. So that isn't true. I think it will depend on you providing more information, though. I'm happy to arrange a consultation with you, Ash, and we can discuss exactly what it is that your employer is saying. What are you not entitled to? It really will depend also on your employment contract. So it could be that the employer is saying that you don't get the same entitlements because you have an employment contract which limits the entitlements that you can receive. And if that employment contract is drafted legally, then it is true that it could limit your severance entitlements. So very important across the board for Ash and for anyone else, very important that we review your employment contract to see what your entitlements are. Many contracts do not meet the standard in order for them to be legally drafted employment contracts, and therefore you are able to obtain your full severance entitlements. There are some employers who get it right and who have good employment contracts, and in those situations, your severance entitlements are often limited to what the contract says. So let us review the contract. You can contact me. You can find out more about this on our website at employmentlawyer.ca. Contact us at help@employmentlawyer.ca, and I'd be happy to arrange a consultation with you. Okay. We have more questions here. Let's move on to a question on YouTube from DF. My partner was recently let go from their part-time job after 3 years. It's only 2 to 3 days a week, but has been consistent for the last 3 years. The letter stated that due to changing business needs, they were letting him go. However, there was nothing else and no further communication. Should he receive any severance, or does that only apply to full-time staff? Great question. Absolutely, your partner is entitled to severance. Again, let's look at the contract. Let's see if the contract tries to limit what those severance entitlements are. But presumably, yes, your partner is entitled to severance pay. Doesn't matter if they work part-time or full-time. They are going to be entitled to severance based on various factors, including their age, their length of service, which in this case is 3 years, the type of job that they're performing, and the availability of similar jobs in the workplace, in the market right now, in that industry. And at this point, we've been talking a lot about severance, which we usually do, and what someone's full severance entitlement is. We say it could be as much as 24 months, according to the law. And so it's a good time for me to raise a tool that we have called the Pocket Employment Lawyer tool. As part of that tool, we have something called the severance pay calculator. You can find this, as you see on the screen, at pocketemploymentlawyer.ca. And it is a free and anonymous tool that you can use to determine how much severance you are entitled to. I encourage everyone to use it. Again, free and anonymous. You don't have to have been terminated. You could just be really curious to see what your severance entitlements would be if you ever are terminated, or of course, if you have been terminated, check out our severance pay calculator that you could find at pocketemploymentlawyer.ca to determine how much severance you're owed. It's a free and easy tool to use. The tool will ask you some questions and you will provide the answers, basic questions like your age, how long you've worked for the company, what your position was, perhaps how much money you earned, and then it will spit out very quickly the range of entitlement that you have in terms of your severance entitlements. And that's a great tool to give you an idea of what you're owed. And then you can contact us and we will help you obtain those severance entitlements. Okay. So I hope that helps, DF. And if there's any follow-up, please post it in the chat. Okay. We have a question on YouTube from Kevin. I've been at a new company for 6 months. I'm really unhappy. The employer isn't training me. The contract says 1 week of severance under a year. Is that legally binding if they lay me off? I make 6 figures. Okay, great question. So if you work for a company for under a year, yes, it is true that your basic severance entitlement or your minimum severance entitlement is 1 week of pay. However, in most cases, you're able to obtain more than that. That is only the bare minimum that you are entitled to if you've worked for under a year. Again, this will come down to your employment contract. You will get the 1 week no matter what, okay, unless your employment is terminated for cause, which is a whole other issue that we can talk about afterwards. But presumably, you will get your 1 week minimum severance payment. Then we look at the employment contract to see, is it possible, Kevin, to obtain more for you? In most cases, it is. And it will depend on what language exists in your employment contract. If there is language that tries to limit your severance to only that 1 week minimum, and if there isn't legally enforceable language, then you're going to obtain more. You're going to obtain your full severance entitlement, which could be anywhere between 4 and 8 months, potentially even more, based on the fact that you were in 6 figures. It will also depend, of course, how old you are, what industry you work in, what your position is. Note also, Kevin, that, because you said you're unhappy, potentially you might resign because you're unhappy. If you do resign your employment, you are not owed severance. Okay, you're only owed severance if you're terminated. If your employer takes the step of terminating your employment, if you take that step because you're unhappy or for whatever other reason, you might have another job lined up, then that is called a resignation. You're not owed severance pay. You'll only be owed any of your outstanding wages. Okay. So Kevin, I hope that's helpful. This is not an uncommon situation. It's a very common situation. And we're happy to help further if that's necessary. Okay. We have a question from R. Mac on YouTube. My wife is currently on a parental leave and just received a note from her employer that her position is being eliminated. Not sure if this is discrimination, but if it is, how would we prove that? And then RMAX says his wife has been at the company for 8 years. They don't have a great track record on how they treat people on leave. Okay, good information there. So first of all, the simple part, if the position is eliminated, your wife, if she's not being offered a different position, has been terminated. And if her employment has been terminated, she, like Kevin and everyone else who's asked questions about severance, she's owed severance. And again, it will be based on her factors. We know she's worked there for 8 years. What's her age? What was her position, etc. And again, she can use our severance pay calculator to get a sense of what her severance entitlements are. If they eliminated the position, potentially it's discrimination, but it also may not be. It depends on if they are eliminating the position as a result of her being the one occupying the position And so really they were just trying to terminate her, or if they were just eliminating the position for other business reasons. If they were eliminating the position for various business reasons that didn't have to do with your wife, then that wouldn't be discrimination. It has impacted your wife's employment, but they aren't treating her differently in her employment, which would be discrimination. However, it is possible that it is discrimination. If they told your wife that, and this does happen, I've seen it many times. So if they told her that her position is being eliminated, and really they're just saying that as a way to get rid of her, then she could be owed human rights damages on top of her severance, because that might be discrimination, which triggers human rights damages. Because they were trying to specifically get rid of your wife. Maybe it has to do with the fact that she has been on a leave. And that would be a problem, right? That would be prohibited under our human rights legislation in Ontario. So I hope that's been helpful, Armac. Why don't you also arrange a consultation with us and we can find out more information? Maybe, it does matter that the company has a track record of this. That could impact the case. We could be able to show with evidence that this is something the company does regularly. They get rid of people on leaves, and there is some systemic discrimination that's going on there, which would obviously be legally problematic. But again, as a very basic minimum, if the position's eliminated, your wife is owed severance pay, and we can help her obtain that. So please contact us. Again, you can contact us at help@employmentlawyer.ca. Okay, good question. We have another good question from Pete. Let's get into this one. On YouTube. Hello, the company I work for is being sold. We were offered employment at the new company, substantially similar to the previous job. Can I reject the offer and be paid severance? Okay, so this is a trickier situation, but it does happen. So if you don't want to work for the new employer, you work for a previous employer, you're being offered a new job at the new employer because the company is being sold, then if you don't want to accept that new position, there is a termination, and your previous employer will have to pay you severance, okay? Not the new employer, because you haven't worked for them. However, this will depend on the industry. So in most industries, that is the case. If the company is being sold one company to the other, and it impacts your employment, and you aren't going to work for the new company, your employment has been terminated. You're owed severance pay from the previous employer. However, the reason why it gets more complicated is because you have a duty, like all other employees who are terminated, to look for new work. Okay, there's two obligations that exist in a termination in Ontario. One is that if you're terminated, your employer owes you severance. But two, the employee has an obligation, on the other hand, to look for new work, to try to reduce the severance pay that the employer owes them. This is an obligation that the law puts on the employee who has been terminated. So, Pete, if you don't take the new job, your previous employer will say, well, the new job is the same job. You work for a new company, fine, but that's really just semantics. It doesn't change what your job is, how much you're being paid, who your colleagues are, etc. And so if that is really the case, your commuting time is the same. We had a question about that earlier. If all of those things are essentially the same, then your employer might have a strong argument that you have failed to satisfy your obligation upon termination, which was to look and accept similar employment. Okay. However, many times this happens, the job is not identical. That you might get paid the same, but it could be a different work location. It could be a bit of a different position. I've had many cases like that. And if you're being offered a different position or something is different about the position, even if the pay isn't different, then that could be what's called a constructive dismissal, again, where your employer is substantially changing a term or more terms of your employment. You don't have to accept that. You will be owed severance pay. And in that case, your employer will have a difficult time arguing that you have failed this obligation of yours to look for new work, because you didn't have to accept that job with the new company if it was different in a material way. Okay, if it was not different in a material way, then you don't have to accept it. No one can force you to do anything, but it may impact your severance entitlement. So Pete, I hope that was helpful. Again, a very common scenario. Each case is different, though. It really depends on what the new position is. How different is it from the old position? How different is the new company from the old company? So arrange a consult with us, and we can discuss further and then give you more specific advice for your situation. Okay. So Pete had a follow-up. The new employer is saying that they're keeping the same working conditions as previous job until end of 2024, but beginning of 2025, are they allowed to do that? Yeah, so that could be a problem. If you have the same working conditions for a period of time, but not forever, and you already know that certain aspects are going to be different about the job, Pete, then that could be a constructive dismissal, and you wouldn't have an obligation to accept that new job. And the little time we have left, I just want to talk about another important topic. It's called quiet vacationing. And I want to raise this because it is the summertime. We have good weather. Many employers are trying to find time. Employees are trying to find time to vacation. And this notion of quiet vacationing is essentially where the lines between family and work become more blurred. This is very common. And now that remote working is very common since the pandemic, employees are finding it difficult to find time away from the office. And so what they do is they engage in quiet vacationing, which means that during the workday, they will try to ease some pressure. They might go and do errands, go on lunch dates, go for a midday workout, etc. Very common in the remote working world. The question that many people have, and that I've dealt with as an employment lawyer, is that problematic? Can an employee do that? And really, again, the answer is it depends. If the company is a company where all they really care about is that you do your work, you do it well, you achieve targets, they don't care when you work, then yes, there's no issue with you engaging during the work day or during regular business hours in some of these other things, right? As long as you get your work done. However, many companies do have an issue with it. They want you to work during working hours. They want you to be responsive on email and direct messages, etc. And so it would be a problem if you engage in these other activities during working hours. This could lead to a complicated case of an employee being terminated for what's called cause. We've seen that happen before. So it's the summertime, like I said, many employees are doing this. If you're one of those employees, really think about whether your employer permits you to do so or not. If you want to have a consultation about this, I've advised other employees on this case, again, because it's so common and relevant now that we're in the summer and we have remote working. So you can contact us at help@employmentlawyer.ca and we can arrange that. We're out of time for today. This has been an amazing session. We got through many great questions on various topics in employment law. And I will be with you again soon. We have another live stream session tomorrow at 9 a.m. Pacific time or 12 p.m. Eastern with my colleague Dan. So please feel free to tune in for that. It was great seeing you, and I'll be with you again soon. Take care.